if we consider Maharashtra in particular, Maharashtra has a prevalent rent control legislation, which is pretty robust, and the rent control legislation, however, has certain provisions which are dated or which are not in sync with present commercial arrangements. If this act is to be implemented in Maharashtra, the state could either implement it by way of modifications, amendments to the present legislation, or introduce a whole new legislation altogether. In any event, if amendments are to be made or if a whole new legislation is to be introduced in the state, there are certain provisions that the state will have to consider, certain aspects that the state will have to consider. One is that there should be a requirement to compulsorily register rent agreements, irrespective of the tenure of these rent agreements. So even if a rent agreement is for a duration of less than 11 months, it would be absolutely compulsory. It should be absolutely compulsory rather to register this rent agreement. Two is that leave and license agreements, which is the norm in the state presently, will have to be brought within the purview of this act. Leave and license agreements are already covered by the present Rent Control Act, but if a new legislation is to be introduced, then leave and license agreements will have to be brought within the purview of this act, and especially from a dispute resolution mechanism, if not to cover commercial aspects. Three, the present Model Tenancy Act excludes industrial premises from its purview. Now, in Maharashtra, one will have to consider, and the state will have to clarify whether premises in an IT park or in an industrial park would be covered within the purview of this act. Four is there should be an integrated dispute resolution mechanism, an exclusive dispute resolution mechanism, irrespective whether a rent agreement is registered or not registered, or irrespective whether information or intimation of the rent agreement has been sent to the rent authority or has not been sent to the rent authority. And five is the state should generally hold itself back when it comes to intruding upon commercial aspects of a transaction. The state, like in the present Model Tenancy Act, where it prescribes the quantum of security deposit, it would not be advisable to have such a prescription. State should stay away from prescribing the quantum of rent or the quantum of security deposit that parties may agree to. In fact, the state should make provisions for a landlord to appropriate the security deposit that is placed with it if there are certain breaches that a tenant commits.